Días con todos, con todas y muy buenas tardes también con todas las personas que se conectan de otras latitudes. Bienvenidos a esta sexta masterclass de Latin American International Arbitration y primera masterclass del año 2021. Es un inmenso honor para el Latin American International Arbitration LIA tener como invitada de honor en esta oportunidad a la doctora Gabrielle Kaufmann-Kohler. La presentación debida estará a cargo de la doctora Diana Drullers, vicepresidenta de Latin American International Arbitration LIA. Simplemente a modo de bienvenida, agradecer a todas las personas que desde hace 10 meses, desde el mes de mayo del 2020, decidimos fundar el Latin American International Arbitration con la finalidad de crear un espacio de diálogo y discusión del arbitraje internacional, desde luego en América Latina, pero también en el mundo. Y en esa medida, el LIA ha venido organizando masterclass o conferencias magistrales, invitando a expertos internacionales para que compartan con nosotros sus experiencias, sus conocimientos y desde luego también nos inviten a reflexionar sobre los diferentes tópicos del arbitraje internacional. En esa medida es un inmenso honor dar la bienvenida a la profesora Gabrielle Kaufmann-Kohler. Gabrielle, bienvenida, muchas gracias por participar en esta primera masterclass del 2021. No puedo terminar sin antes saludar y congratular a todos los miembros del IA y en general a todas las personas del mundo que están enfrentando de manera valiente esta pandemia. Solidarizarnos con todas las familias y con todas las víctimas de este letal virus y hacer votos porque muy pronto podamos tener nuestra primera conferencia LIA de manera presencial. Desde luego, una vez que los médicos hayan podido vencer a este letal virus que está causando graves daños en la salud de las personas y ni qué decir en la economía. Desde esta tribuna del día nos solidarizamos pues con todas las familias y desde luego un honor y un agradecimiento a todos los médicos, enfermeras, a la policía y a todas aquellas personas que están en el primer frente de batalla luchando para vencer este letal virus. Sin más, damos la bienvenida a la doctora Diana Drullers, vicepresidenta del Latin American International Arbitration. Adelante, Michelle, para que puedas presentar.
Muchas gracias, doctor, por estas palabras de bienvenida. Sin más, presentamos a la doctora Diana Drullers, quien es vicepresidenta del Latin American International Arbitration LIA, abogada egresada de la Universidad Católica Andrés Bello, se entrenó en los Estados Unidos en la Universidad de Harvard y Universidad de Houston, y en Colombia como mediadora y en la Corte Internacional de Arbitraje ICCA y la Asociación Americana de Arbitraje en materia de arbitraje. Es exdirectora ejecutiva del Centro de Arbitraje de la Cámara de Comercio de Caracas y secretaria general de la Cámara de Comercio Internacional ICCA en Venezuela. Ha sido responsable de ejecución de proyectos BIB y CAF en materia de arbitraje y mediación. Representa a Venezuela en la Comisión Interamericana de Arbitraje Comercial, es miembro de la Comisión de Arbitraje de la ICCA, es miembro de los directorios de la Federación Internacional de Instituciones de Arbitraje Comercial, es fundadora de la Fundación Francisco Herrera Luque y la Fundación Reveira y Fundación Caraballeda. Sin más, cedo el uso de la palabra a la doctora Diana Drullers, quien actualmente moderará este panel y nos ayudará con la moderación de la ponencia de la doctora Gabrielle Kaufmann-Kohler. Doctora Drullers, adelante.
Hola, buenos días. Encantada de estar con ustedes hoy. Leyeron un currículum un poco outdated, la verdad, pero bueno, igual estoy encantada de estar aquí. creo y me siento, primero, me es un honor participar y privilegio estar participando con Gabriel. Yo creo que, como les decía, no necesita mucha introducción porque muchos la conocemos de puro nombre desde que uno, digamos, abre la puerta hacia el mundo del arbitraje. Entre todas las cosas que le voy a contar de ella, que son las cosas objetivas, creo que lo que a mí siempre me impresionó es que Gabriela ha sido pionera. Y pionera no solamente porque es mujer y está en el mundo del arbitraje, sino que fue pionera realmente dentro de lo que se llama tanto las actuaciones en el mundo del arbitraje de inversión y las actuaciones en el mundo académico con respecto a lo que es el arbitraje y traer las nuevas generaciones hacia el arbitraje. Gabriel ahora acaba de dejar la presidencia de ICA, que es el International Council for Commercial Arbitration Institutions. For Commercial Arbitration, estoy tan acostumbrada al IFCAI que aún me equivoco con eso. Ha hecho su práctica. Denme un segundito porque esto, ok. Ahora sí. Ha hecho su práctica. Ay, qué pena, pero se me ha cerrado la pantalla. Denme un segundito, por favor. Ok. Ha hecho su práctica internacional comercial en Investment y Sports Arbitration, ha actuado en más de 220 arbitrajes internacional, casi siempre como árbitro, y actúa ante diferentes centros de arbitraje, incluidos ICC, ICSID, la AAA, el CIA, SIAC, CIETAC, que es China, y conduce sus arbitrajes bajo las reglas de todas las instituciones internacionales. Está ranked en las mejores 10 árbitros del mundo y en el 2016 concluyeron que era el árbitro más influyente en el mundo. Les contaba la parte académica porque es profesora emérita en el Ginebra University Law School y también es la fundadora, directora anterior y miembro de la facultad del LLM en Ginebra de International Dispute Settlements llamado MIDS, que es un programa conjunto entre el Graduate Institute of International Development Studies y el Geneva Law School. Es profesora en diversas universidades como en profesora, lo que llaman visitor professor en Singapur, en Beijing, en Georgetown y presidente de el Council for the Center of International Dispute Settlement. Se dedica como docente las clases de arbitraje comercial y arbitraje de inversión y participa en muchos proyectos de investigación. Es presidente honorario de la Asociación Suiza, de la cual fue presidente desde 2001 hasta el 2005. Es la fundadora del Foundation for International Arbitration Advocacy, presidente del Advisory Board y además fue miembro de la Corte de la ICCA, de la Corte de Londres, del Board of Directors de la Asociación Americana de Arbitraje, el Swiss Delegations a UNCITRAL, incluyendo el Working Group 2 de transparencia hasta el 2014 y ahorita el Working Group 3 en la reforma de Investor State Arbitration. Gabriel ha sido profesora. Yo creo que, si le soy sincero, Gabriel, y me excusas, pero sigue siendo profesora en muchísimos sitios y la verdad es que, como te decía antes, para nosotros es, o para la gente de mi generación, quizás los que vienen después no tanto, pero para la gente de mi generación Siempre ha sido una delicia ver que por delante de nosotros hay una persona que nos ha abierto muchos campos y que bueno, que siempre estaremos agradecidos por eso. Además, muy interesante las publicaciones, que no les voy a decir todas, pero hay una en particular que me vino a la mente cuando Carlos me pidió que me ocupara hoy. Y es una publicación que hiciste hace un buen tiempo, en el año 2005, sobre The Use of Information Technology in Arbitration. Y yo sí me he acordado de esa publicación, con todo lo que ha sucedido ahora y todo lo que hemos podido utilizar dentro del arbitraje. Sin más, los dejo con Gabrielle, que nos va a tocar dos temas muy particulares hoy, y el mecanismo va a ser que ella va a tener su presentación, va a hablar y luego vamos a hacer un break para preguntas sobre el primer tema y posteriormente un break para las preguntas del segundo tema. Las preguntas las pueden ir haciendo en el chat y nosotros las vamos a ir consolidando. Sin más, bienvenida, Gabrielle.
Muchísimas gracias, Diana, para estas palabras tan amables. Gracias a Carlos también para la bienvenida. Y me da mucho placer estar hoy virtualmente en Lima y agradezco la invitación y espero que estén todos bien, aunque las circunstancias no son muy favorables estos días. Voy a pasar al inglés porque es la lengua franca del arbitraje y me sale más fácil hablar de estos temas en inglés. I've chosen two topics for today. One is the draft code of conduct for adjudicators that will be discussed in 10 days actually at the working group 3 of UNCITRAL, and then virtual hearings, because this is nowadays very much day-to-day business for all of us, and we see now the first decisions on challenges about virtual hearings coming out, and it's important to reflect on this. So I thought these were just topics that would hopefully be interesting at this stage. I have a PowerPoint that I should now start sharing the screen. Do you see it now?
Yes, yes.
Yes, good, excellent. So, so this is, now I have to make sure that I have the right, is this it? Yes, good. So these are the two topics. And if I go now first to the draft code of conduct, we'll divide this into 4 parts. The first one is context, just so that we're clear. Yeah, sorry, I'm lost in my papers. Context, how does this come about? What are the standards of conduct for arbitrators? We have known those for a long time, actually. What is the main content of the draft? And there I will focus on some of the main provisions, and then some outlook, and then we can break and have a conversation, and then I'll go to the other topic. So, I have too many switches here, so I have to be careful which one I switch so that I don't get lost. Yes, you of course know that investment arbitration was non-existent practically. In the 80s, it then experienced a strong boom from the years 2000 on, and then, not surprisingly somehow, came the backlash of more and more criticism against investment arbitration. This was about lack of transparency. This was about lack of consistency between among decisions. It was about excessive cost and duration. And then there was another group of criticisms that were focusing on the person of the arbitrators and their mode of appointment. And I call this more specifically, the legitimacy criticism. And that gave rise specifically and is meant to be addressed in the draft code of conduct. It's not the magic potions as you see on the screen, but hopefully it will fix a few things. Now, the reform initiatives that arose from this criticisms and backlash have been partly substantive, and that is for the states have more and more changed the treaties. They've changed the substantive protections in the treaties, they narrowed them, or they made them more specific, more detailed. But then we also have procedural reform initiatives. Some of them have been already implemented in treaties. It goes from just abolishing investment arbitration entirely through setting up courts or just or providing more specific rules on procedure. Where are these reforms implemented? I already mentioned the states. The states, of course, do play the major role in the reforms because they are the masters of the treaties. And then there are two places where the states meet and discuss these reforms. And of course, the first one and the main one right now is UNCITRAL and more specifically Working Group 3. In Working Group 3, we have two types of reforms that are currently being discussed. One is called incremental, and incremental simply means it adds something to the existing system, and it means to improve the existing system. And the other changes are called systemic or structural, and they're meant to make a change to the structures of the current system, which is essentially creating a multilateral investment court or an appellate mechanism to be added to the present arbitration system. This is all in the course of discussion. It's been rather slowed down last year because of the pandemic and the difficulty to meet in person, but it is now again picking up speed through online meetings. The one other forum that is important for the reform is ICSID. ICSID has a large project going about rule amendments, and that is of course incremental because the system of ICSID cannot be changed, of the ICSID convention cannot be changed without unanimity of the state parties. Now, and that these two fora have now joined for purposes of the draft code. But before I go there, let me just reflect briefly on what the existing rules of conduct are for arbitrators, because sometimes I feel people are now saying this is a new draft code, this is all new. No, this is not new. We have had rules about conduct for a long time. The sources are diverse. We, of course, have national arbitration laws and the jurisprudence of national courts, very important. Institutional arbitration rules. We also have a lot of soft law. For instance, the IBA guidelines on conflicts of interest are very important soft law source. And then we also have the New York Convention that has a bearing on how arbitrators behave and the decisions on enforcement of awards. Now, what are the main obligations that are imposed on arbitrators? Of course, the main one, that is the pillar of the system, is independence, impartiality, and to be able to implement that a disclosure obligation of potential conflicts. Then there is efficiency. Efficiency includes availability, but it's also an important part of the obligations of the arbitral tribunal. Confidentiality includes the secrecy of deliberations and the duty not to reveal anything from inside of the arbitration to outsiders. That may be somehow alleviated by the current trend towards more transparency in investment state arbitration. There are other standards as well. The compliance with the law and the rules that govern the arbitration are certainly a requirement for arbitrators that essentially goes to due process, equal treatment. And then we also already have sanctions for breaches of this conduct. One is removal or disqualification of arbitrators. One is, depending on the type of breach, annulment, non-enforcement of the award. In some places, depending on the national law that governs the arbitration, there can be civil responsibility, at least for gross negligence of the arbitrators. We have seen in Spain, and maybe you follow the Spanish jurisprudence. In Spain, we have seen several decisions on responsibility of arbitrators for instance, the obligation to reimburse fees or pay some other damages. So there are sanctions in place. Now, is this different from the position of judges in terms of conduct? Not really, actually. And that's not a surprise because the function of administering justice is the same and the requirement for impartiality is the same. There are two differences, though, that one should mention. One is that the judge is part of a permanent judiciary, and being part of a permanent judiciary, she is subject to the disciplinary power of exercised either by the president or some commission of the court. There's nothing like this in arbitration for good reasons, because it's an ad hoc tribunal system. And then the other difference is that the issues of impartiality come up differently. For judges, the main issues are more structural institutional independence in the sense that they must not be prone to political inference or inference from the executive branch of the government, for instance. That does not arise for arbitrators. For arbitrators, what is more difficulty is the fact that they have other professional activities and therefore may have all kinds of connections. And also they are appointed by the parties. If I say all this here, it's because it is linked to the reforms in general and the idea that maybe a court could resolve a number of these differences because ad hoc arbitrators would be replaced by permanent judges. Now, having said all this and keeping it in mind, let's go to the draft code itself. You see the pile of old books. We have all kinds of codes already that do exist. And I have about, I have 3 pages of a list that a research assistant put together for me. And there are all kinds of code of ethics and conduct for arbitrators, are all sorts of institutions, and there are international organizations that have done some too, and there are courts, national courts, international courts. I see one that features quite high in my list, is Cámara de Comercio de Lima, Código de Ética of 2008. So there was a lot of inspiration to get from to define the content of the code. I should also mention that there are codes now incorporated in a number of treaties investment treaties. CETA, for instance, is one example. CETA is the EU-Canada free trade agreement that has an investment chapter. Now, the code is meant, and that is said in Article 1, for adjudicators. It doesn't say arbitrators, it says adjudicators, and that is done on purpose to cover both arbitrators as we know them today in investment arbitration, and possibly permanent or quasi-permanent members of standing institutions, for instance, an appellate mechanism or investment court. The code is meant to be binding, and that differentiates it from soft law type codes, and that is found in Article 12. Now, how is this implemented? Well, there's, of course, voluntary compliance is very much counted on, I think, by the drafters. And then the existing possibilities of removal of arbitrators, of annulment of awards, of non-enforcement of awards, all this is untouched by the guide and continues to be governed by the governing law of the arbitration, which for an ICSID arbitration will be the ICSID Convention, and for non-ICSID investment arbitration will be the national law of the seat of the arbitration. Now, there are other, let me just, yes, there were other ways of making of enforcing the draft code that have been discussed at UNCITRAL, and it was striking to see how government delegates came up with all kinds of way of almost punish arbitrators, I felt. Reputational sanctions, a list, sort of blacklist of arbitrators who are serial breachers or just one-time breachers of the rules, a notification to professional associations. There was also some talk of monetary sanctions, probably more difficult to implement. Now, how will the code, and that goes on into implementation as well, how will it be made applicable so that it is indeed binding? It could be incorporated into treaties. It could be incorporated into arbitral rules. It could be made part of the Declaration of Independence, which arbitrators must sign at the beginning of an arbitration. It could be agreed just by the disputing parties. So there are a number of ways in which it would be implemented if it goes forward. Let's go to its content now. Article 3 is the core, and you see a core on the slide. And that says what? It says independence, impartiality. It says integrity, fairness, competence. That is a little less well-defined somehow. And it also says higher standards, which to me sounds more like an aspiration than the true standard. But nothing so far that is really new. Diligence, that goes with efficiency, I suppose, and the need to comply with the law that governs the arbitration. Efficiency is specifically mentioned. Then there is civility. Civility, I have not listed in the standards before. That probably goes to collegiality, which is an expectation within the tribunal of the behavior of arbitrators. Is also terrorized by national jurisprudence on impartiality. And then probably it also means that you have to behave well, you have to be well-mannered in the way you treat the parties. So that may be a requirement that we have not seen so far. Confidentiality is nothing new. We had seen this before. We have this already. Now, Article 3 is the core, and the other articles of try to implement this by more specific provisions. One way of implementing impartiality independence is, of course, to have disclosure obligations. There's a long list of disclosure. I thought that was tedious to go into every detail. Let me just highlight what I thought was of more interest. You see that you have to disclose professional, business, other significant relations. That's very normal. You have the same thing in the IBA guidelines. Within the past 5 years, you will know from the IBA guidelines that we have 3-year time limit. Here it's 5, probably because it's understood that somehow investment arbitrations often last longer. Then you have to disclose your relationships with with the parties, with other arbitrators, etc. You also have to disclose your relationships with experts in the proceedings. And that, to me, will probably be a challenge to many arbitrators. I don't know whether everyone here has a system that allows to search for all the experts that have appeared before tribunals on which you sat. I don't have it yet. I'm setting it up. But it also means that at the beginning of the arbitration, when you accept the mandate, you will probably not know who the experts will be. So it emphasizes the continuing duty, which is also emphasized elsewhere. But this is a practical example where once you receive the memorials and you see who the experts are, you have to go and check your database and send possibly a disclosure to the parties. Then what needs also to be disclosed is all ISDS cases in which the candidate is currently or involved or has been. That's just a list of investment arbitrations. That's not that complicated. What may be more of a problem is and other international arbitrations. That would cover all commercial arbitrations. And often commercial arbitrations being confidential, you would, under different rules, not be able to disclose the names of the parties. So that may be somewhat of a difficulty, and maybe this bracket should better be left out. There's an other provision that is interesting is Article 6. It is about double hatting. It's called limit on multiple roles. Here's just a chart that shows you from empirical data, shows you the number of cases with double hatting counsel and double hatting arbitrators. What seemed interesting to me is that you see it growing over the years. I would have expected that double hatting arbitrators would rather have a diminished number than increased, and that is not what the data shows. So it is certainly something that needs to be addressed if we look at this. Now, how is it addressed? It's addressed right now with a provision that is still quite open, because it says that the adjudicators shall refrain from acting or disclose that they act. So it's either a prohibition or a disclosure requirement. And as a matter of principle, it seems to me that it is preferable not to accumulate the role of arbitrator and expert or counsel. And that is very different from commercial arbitration. It is because you have the same legal issues arising again and again in investment arbitration. Irrespective of the treaties, what is fair and equitable treatment will arise in practically every case. So it is better not to be on one hand arguing one thesis and on the other having to rule on this thesis. Now, is it good to have a prohibition, which would be the logical consequence of the principle I've just set out? I'm not entirely certain, and that the only really convincing objection I heard about this was about that it goes against diversity. We know that we have a serious lack of diversity in investment arbitration among arbitrators, and that goes to gender, it goes to regional lack of diversity, and it goes to lack of age diversity. Now, if we have a prohibition of double roles at the same time or within a certain time period, it means that someone who's new in the arbitrator pool, who has the first appointment, will need to drop, if he wants to accept the arbitrator appointment, will need to drop all his counsel cases. Now, she may not be able to survive because the arbitrator cases may be less remunerative and slower, slowly over years. So that would mean that it would probably reinforce, a prohibition would probably reinforce the existing pool and go against the expansion of the pool. So that's something that will have to be thought through very carefully when in the discussions that are forthcoming. Can go faster about this. This is about no ex parte contacts, which certainly is a rule that we do know. There lacks an exception here, which is that in the course of the constitution of the tribunal and the choice of the president, ex parte contacts are not only generally acceptable, but also desirable. No delegation of decision-making power, that is something that we are familiar with as well. It's the whole debate about excessive powers, excessive delegation to arbitral secretaries. Now let me carry on. That can be faster as well because it simply says that adjudicators, that's the implementation of the confidentiality standard that we know already now. But the way it is put could go against a practice that is now inserted more in newer treaties and that tribunals may sometimes start to use, is submitting a draft of the award to the parties. It can be quite useful actually in avoiding mistakes, and so that should be made more precise as well. So that leads me to the end of this, not entirely to the end, but let me just ask you now, anything missing?
Anything missing? You know,
missing in the draft code, that means are there things that should be in the code that are not? I know that many people in the arbitration community will say there are many things in the code that should not be there, but that's a question of perspective. Is there anything missing that it would be really important to regulate?
I don't know if anybody in the public.
Has anyone an idea?
We have no questions in the chat room. And I want to know, do you think that there's anything you would have liked to see there that you're not seeing? I'm obviously not going to ask what you think is repetitious, because this is like the the trying to make simpler and more understandable, as you said, the codes that are all over the world. But is there anything that you feel could have been one notch above what is there? Or what is it in others?
No, I don't think so. I've tried preparing for today. I've tried to think about, no, I think it's fairly complete. The value that I see in this code is that it will create some kind of global standard, right? Right now we have many different standards, and it will then need to be seen if, for instance, courts at the seat of an investment arbitration that is a non-ICSID arbitration, and 40% of investment arbitrations are non-ICSID, so they're not all going to annulment committees under ICSID. They're also more and more going before national courts. Will they take this into account? I would think they probably would, as they have actually done also for the IBA guidelines, even though the IBA guidelines were not binding. So no, nothing to add, I would say. What in the discussions that come will be important. And with respect to the discussion, I should say that, as I mentioned already, there's a working group 3 session from February 8 to 12. This is scheduled for discussion on the 12th. And then in March, there are 2 days of additional meetings that are joint meetings, ICSID, UNCITRAL, to further discuss the code. So I could see, it was interesting to see when this was first discussed in the working group, and I was in October 2019, the state delegates were very favorable to a draft code. So it looks like a low-hanging fruit, and it may well be implemented much sooner than other reforms. So that leads.
Yeah, I think, if I may, I think, as you say, this is a way of making the different codes into one instrument and one, not more known, because I think it's hard to know, I think IBA codes are really well known, but it gives it some sort of formality and uniformity that the others don't have.
Yeah.
And would be, and I think one of the biggest challenges sometimes in arbitration is that since you're working through cultures, with and through different cultures and different levels of knowledge of arbitration, and specifically in investment arbitration, where you have sometimes very well set up teams and others not so much. When you see imbalance between the parties, and then and a lot between the chosen arbitrators in different tribunals, this may be something that creates the uniformity that is somehow wanted, although uniformity is exactly what you don't want in arbitration. I don't know if I make my meaning clear in that sense, but it does give people a little more transparency as to what the arbitrator should be acting as.
No, I think it's probably, when it first came up, I said, oh, this is a very boring topic, because we all know what the rules are, and there's so many codes of conduct out there, and why should we waste the time of all these delegations on doing just one more that will necessarily be a compilation of all the existing rules. But then I must say that I changed my mind somehow, because I see the value of having a transnational global standard. And it is true that there may be different understandings of what is expected of an arbitrator. So that may be helpful, and it will have the seal of the UN, and it will have the seal of ICSID, so that will give it quite some weight.
Yes. Yes. Yes, definitely. A lot more than just an instrument from any other institution that manages arbitrations or some law or some bar association somewhere or some law in some other country. Definitely, I totally agree with you. I'm sorry, I interrupted you and you said this is leading into...
No, this is leading into the outlook, but the outlook I've just given, I think we will probably see this. I would be more at ease to give you more of an outlook in 10 days, because then I will have the sense of the floor at UNCITRAL. But it's likely that there is some pushback now on some provisions that are considered not practical or too complicated to put into place or too demanding. But except for that, I think there will easily be consensus on a code at some point.
Yeah, well,
too far away.
The high standards, trying to implement things, you need to put up high standards in order to be able to sort of get into it, because if your standard is very low, you're never going to go anywhere. So even though some of the things portrayed may be difficult, in the long run, it's better to have it a little more difficult than too easy.
Yes, you can say that. For instance, I saw displayed the highest standards of competence. What does that mean? I mean, what's the highest standard of competence? Who will say that? Higher than what? What does that mean? But it's a nice declaration, let's put it that way. It's a nice statement, but in terms of a rule, it's how do I do this? How do I display that I'm competent? I don't know how to do this.
Too many interpretations to the same.
Yes. Good. I see there's, so that leads me to the
I'm sorry, Diana.
end of the first topic. So we could, if there are questions on the first topic, you're welcome to raise them now.
Yes, there's one question that says, you were speaking about the problem of subordination of the judges to certain circumstances in order to favor states. Do you think that that nowadays the judicial participating in arbitration in some countries is a problem for arbitration?
No, I was saying that when you speak of a court as opposed to an arbitral tribunal, one of the independence of a court, you need to pay attention to the fact that this court must be insulated from political interference. And that is less a problem for arbitrators because they're not part of a state. They're not part of a judicial, of a judiciary. They're just private individuals. And so that is what I meant. That there's something different that occurs now in investment arbitration is the polarization. You have some arbitrators that are always acting for, always appointed by arbitrators, and others are always appointed by investors. And then you have those in between that have either role or are chairs. And so that I find this somewhat of a difficulty, yes, if you think about impartiality. But that's just about the current system, yeah.
Okay, we have another question from Mr. Carlos Gabuardi, and he will, please go ahead, Carlos.
Thank you. I have a question for Dr. Kaufmann-Kohler about a piece of information you provided us about 40% of investment arbitration, you said, is not ICSID based. And This, in my opinion, reflects something in terms of the role of ICSID, either in terms of trust, confidence about the reliability of that institution, or something is not being managed correctly, or what do you think? Why 40%, which is a very high amount of cases, is not going to ICSID, which is supposed to be the most idoneous mechanism for investment dispute resolution? I appreciate your comments.
It is true that the share was higher in a number of years ago, and it's somewhat reduced over the years, but there was always a 1/3 that was non-ICSID. The reasons are several. One is that you have relatively strict jurisdictional requirement in Article 25 of the ICSID Convention with respect to nationality. Double nationals, for instance, cannot claim if they have the nationality of the host state, and you may not have these restrictions if you file an UNCITRAL arbitration. Plus, the treaties many treaties give a choice between ICSID, UNCITRAL, or even ad hoc, sometimes ICC, sometimes Stockholm Chamber of Commerce. So some investors may also think that an ad hoc arbitration may be more efficient, more faster. There are all kinds of different reasons for that. Yes?
No, I said thank you very
Sure.
much. I think this is a topic, a very interesting topic.
It is very interesting, you're right, because we have seen more and more national courts now rendering decisions on annulment of investment awards. And they look at it like a good lawyer, generalist lawyer, but not necessarily always like an ICSID annulment committee that is often composed of specialized investment arbitration specialists. And that may provide some surprises, yes. Yeah.
Yeah, arbitration is full of surprises.
Yes, it's also its beauty.
Yes. Okay, Gabrielle, if we don't have any more questions, I think we can go on.
I hope you still have the energy to listen to my second topic that somehow is more practical, but at the same time, I would like to put it in legal terms, because we have heard a lot about the practicalities of virtual hearings, and that is not my point here. Essentially, I have two questions, and these are the questions that most often arises. Can you conduct a virtual hearing even if one of the parties opposes it as a tribunal? Can the tribunal impose a virtual hearing? And that's the question of whether. And then I have another question, which is the question of how, if you do hearings online, then how do you do it so that you're certain that you comply with all the legal principles that are applicable? And to do this, I'd look at these different topics that you see on the screen. I don't think I have to run through them. You do see them. The legal framework. I mean, the legal framework is what we always have to look to when we have a legal issue in arbitration. we would first look to the law that governs the arbitration, right? And here we're not specifically in investment arbitration. That applies to commercial arbitration in the same way. Maybe I should have put the New York Convention at the end, because that is about enforcement of the award. But of course, depending if you make mistakes in handling the arbitration, of course, you may have an issue at the time of enforcement. But when you are within the arbitration process, you would look at the lex arbitri. That is the law that governs the law of the seat, the international arbitration law of the seat. That may have a specific provision on virtual hearings. The Dutch Arbitration Act, for instance, has a provision. Then that resolves your issue. But most often they will not. And so, but they may have rules that help you resolve the question. One first rule is party autonomy. It says that the parties can decide procedure as they wish. Now, assume the parties have said, we want a hearing in presence, we want a physical hearing, then that answers your question. The tribunal cannot impose a virtual hearing. But most often the parties will not have said anything about this. Now they could also, the parties could also exercise their autonomy, not by a direct agreement, but by referring to arbitration rules. And then you would have to look at the arbitration rules and see whether the arbitration rules have any specifics about online hearing. More and more now, institutions have been, since the beginning of the pandemic, have been given guidance to tribunals about this. I think this is so in Peru, this is so in the ICC, there's so in many places. That it does not, that the rules that are set often do not specifically say that you could order a virtual hearing against a party's will. So often you will not find a direct answer to this. What the lex arbitri will also tell you, if you don't have something in the party autonomy or in the arbitration rules, is that the arbitrators have powers to manage the procedure. These are all very basic things, but it always helps me at least to go back to basics to resolve questions. So then it depends a little bit how these powers are framed. If they're very broad, you could say, well, they may well include a power to order a virtual hearing. You could also have soft law. We have all kinds of protocols about online hearings right now that have been drafted in the last months. Those can be helpful. They will more tell you how to go about it and will tell you the technical stuff. They will not necessarily give you the legal answer. Now, we're looking at whether you can order as a tribunal virtual hearing against the will of a party, and if you do it, how do you do it? That is, even if the parties agree, you have to be careful about the how. What is the possible consequence if you don't do it right? Disqualification of arbitrators for bias. We have interestingly seen now several arbitrations where one party has opposed a virtual hearing, and the arbitrators have nevertheless ordered it, and the party that had opposed the virtual hearing then sought the disqualification of the entire tribunal. Let me just jump forward and then come back. Here's one example, Vattenfall versus Germany. It is an ICSID case, but there was a PCA recommendation that was requested from ICSID, and that really said these considerations, whether you have to be fast, whether you have to, how you allow parties to present their case, these are all for the tribunal to make, because the tribunal is closest to the case. And then it says, I do not see that a procedural disagreement reasonably provides a basis for inference of bias. And that is a general rule we know. As a matter of principle, the simple fact that an arbitral tribunal gives a procedural ruling does not manifest bias. You would need something more than to show that the tribunal is partial and is biased against one party. But going backwards, another issue that one may face if the virtual hearing is not properly conducted is, of course, the annulment of the award, if that coincides, if the reason coincide was a ground for annulment, or same thing with respect to non-enforcement. Now, there are a number of legal principles that are involved. One is impartiality, and we all just discussed this. Another one is, and that is probably the main one here, is due process and or sometimes called fairness, and that has a number of expressions that are all covered. Is the right to a hearing? Do you have a right to a hearing? If so, do you have the right to a physical hearing? You have the right to present one's case, which means you have to be able to bring forward your arguments. You have to be able to bring forward your evidence, your witnesses, and then also equality of arms. You have to have equal treatment between the parties. Now, we had that was in the context of an impartiality discussion, but an interesting decision of the Supreme Court of Austria, but there may be others, but this was one that struck me, that discussed all these aspects and came to the conclusion that the fact that the arbitrators had ordered a virtual hearing against the consent of one party was not such a violation. Now, the first question, of course, is the right to a hearing. Do you have a right to a hearing? That very much depends on the legal framework. There are legal systems where there is not necessarily a right to a hearing. The arbitrators could decide to have proceedings on documents only. In other systems, if one party at least requests a hearing, then the tribunal will need to hold the hearing. So if that is the situation, then do you have a right to a physical hearing? That, of course, is a difficult question. The ICCA is now conducting a research project in a large number of jurisdictions, and they will provide reports for each jurisdiction setting out whether there is a right to a physical hearing. Now, I'm trying to resolve this in the following fashion. What is a hearing? A hearing is an oral, synchronous, means simultaneous, everybody there at the same time, an adversarial presentation of oral argument and evidence, that is witnesses and experts. Now, if you think about oral, synchronous, adversarial, it would seem to me that a virtual hearing meets these requirements. But of course, it also means that it must, in practice, be synchronous. For instance, if you have a party that has a very poor connection and drops out half of the time and cannot attend the hearing, or you have an expert or a witness who is in a place where he has a bad connection and cannot really be heard, then you would not have a synchronous adversarial hearing, and the online hearing would not be the equivalent to the physical hearing. So you would need to be very careful about the technology to make sure that the requirements are met. So my conclusion here would be, yes, in theory, the Zoom hearing or Zoom or any other platform is equivalent to a physical hearing. So it is a real hearing, but provided the implementation is made in such a way that the party's right to present one case is met. You could also have an issue with equal treatment, for instance. Let's assume, again, one party has a very poor connection because it is somewhere in a developing country that doesn't have good internet, and another one is in a developed country with all kinds, with high speed bandwidth, broadband, and so on. So that might create an unequal treatment. So, and of course, that would then go to the right to present one's case or equality of arms. That is a ground for non-enforcement of the award under Article 5(1)(b) of the New York Convention, but it is, of course, also a ground for annulment under all the laws, the national laws that I know. So what does that mean? It means that in practical terms, you need to be very careful to test. You have to have a trial run and you need to test the equipment. You need to bring the witnesses, and the tribunal needs to require this if the parties don't provide it. You need to bring the witnesses if they have a poor connection to some place, a center somewhere where they have a good connection, even if they have to travel. This may be more difficult during the pandemic, but I've done it not long ago, and it worked. They had to travel, was in the country to go to the capital and make sure that there they would have a good connection. You have to, if you have to stop the hearing, if you have to interrupt it, you may have to do so because not to run any risk. You have to make sure also that counsel teams are able to well coordinate, and that is one of the main difficulties that I heard of dealing with parties in arbitrations. They are, if a counsel are spread, or everyone is at home and they cannot really coordinate. Of course, they can coordinate by chat, by email, by WhatsApp, and so, but it's not the same thing like being in the same room. So ideally, it's better if the counsel teams are both are in the same room, even if it's separate room, even if they're not with the tribunal. So all these issues need to be carefully reviewed in advance of the hearing with a very detailed hearing protocol and virtual hearing protocol. Now there's another aspect that needs to be taken into account, and that is confidentiality. And we have already discussed that there is confidentiality of the arbitration unless you have a transparent investment arbitration. But most arbitration, at least commercial ones, are confidential. You don't want an outsider to just jump into the hearing. You have data protection and cybersecurity issues as well. So all of this needs to be taken care of as well. You have to have a secure platform. You have to have passwords for all the participants. You of course need to identify all the participants well in advance. You have to have an admission system so that people go to a waiting room first and don't come directly into the hearing room and the like. You also have, and that may be more linked to what we saw before, equality of arms. you will need to take precautions about how to hear the witnesses. You have to make sure that there's no possible undue influence being exercised on the witnesses during their examination or during the breaks or whatever. So I would always make sure they're alone in a room. They have access to IT help if they need it. I would always look at the entire room to make sure that I see whether there are other people in the room, make sure what documents they have access to, make sure they don't have their smartphones with them. They only have one screen with the documents that are projected to them or no screen at all. All this needs to be well planned in advance to make sure that the legal principles are well respected and there is no risk of the award then being annulled or not enforced because things went wrong. Now we discussed this. Now let me open the discussion already here. There's been, of course, all kinds of debates about pros and cons, advantages, disadvantages of virtual hearings, about whether they will stay once the pandemic is over. It's true that right now we don't really see the end, but one day it will be over. Will we continue to have virtual hearings or not? How will we decide when one arbitration should go virtual and the other should not? What are the tests? These are the questions I have, and you may have other comments, and we can certainly open the discussion now on these issues.
I have one first question, Gabrielle. As I spoke in the beginning, you have the article that you wrote in 2005 about using IT within the arbitrations. And I remember distinctly the article because I did use it as a base for a conference that I had to give at the ICCA in Brazil. And your article was fairly new at that moment, and it brought on a lot of discussion as to should we limit the use of IT, or should we make the most of it? And there was a lot of discussion around it. Did you ever think that IT in that sense would include all that we are now seeing and all that we are now seeing being developed for us to use within arbitration?
Actually, we focused at that time much more on filings and the like than on hearings. But I remember at that time, and I don't remember whether it's in the article or not, that I was working with computer scientists, and they were developing this 3D virtual meeting space. And I had tried to set this up for arbitration hearings at the time, and it failed. And then we gave up and they went on doing other things, and I dropped it. But now we don't have a 3D virtual hearings yet, but we're close to it and it will develop, I'm sure. So the sudden expansion is quite surprising somehow, and we did it because we were forced, because otherwise, of course, I mean, we all, at least I do, think it's much nicer to be with other people in the room than just seeing you all on the screen, right?
Yeah.
But then this is very functional, I would say.
Yeah, we wouldn't be able to have as many people in the room, as you say. So you have a certain amount of capacity for people, and then others might not be able to reach out. Let me see if there's questions from the public for now. In the chat, do we have any questions? Not yet. Another question that comes to mind is when presenting evidence.
Jose has a question.
Jose,
Carlos as well.
go ahead.
Yes, well, thank you. Thank you, Diana. Thank you very much, Gabrielle, for this enlightening presentation. Is not an easy topic, in particular the second one. And I think the most difficult question is the one you put onto your slide, is whether the parties have a right to a physical hearing. Because the determination has to be made in advance of the decision, of course, of the arbitral tribunal in case one of the parties opposes to conducting the evidentiary hearing in a virtual or remote manner. And that's very tricky question. I have been confronted to this issue a couple of times already. And I have to say that among the members of the tribunal, of course, we had 4 different views, even if we were 3. Nonetheless, I don't know, subject, of course, of the compulsory provisions of the lex arbitri or the arbitration rules. I mean, there is one, I think, argument for the arbitral tribunal to use. One, of course, is the implicit powers of the arbitral tribunal, and which are these implicit powers they are coming from, but also the duty of the arbitral tribunal to conduct the proceedings in an efficient manner. And then probably my approach would be, or at least it has been so far, is that the party that objects to holding a virtual hearing has to show that these general principles of proceedings, equality of arms, rights to present the case, due process, will be violated in case a virtual hearing will be decided upon, or it will be conducted so. So it will not be very easy, I have to say, for the party which objects to really identify why and at which point the rights of due process and other general principles may be violated if the tribunal decides to conduct the hearings remotely. So what do you think, Gabrielle?
My sense is that probably, and all those who have tried to challenge our arbitral tribunals that have ordered virtual hearings against the will of a party so far have failed to at least the decisions I have seen. And so I think there is a strong argument to say that there's no right to a physical hearing, provided you can be sure that all the technical safeguards are given, that you have an oral synchronous adversarial hearing. Now, at the same time, I'm always trying to make sure that I get the consent of the parties. And so I have on several occasions said, well, let's see in a month from now, and then we rediscuss. And after a while, both parties think, well, this is lasting much longer than we thought, and now let's get it done. So so it's always better if you can avoid having to make an order. But I would have no difficulty accepting that the tribunal has a power to conduct the arbitration as it seems fit, and it has a duty of efficiency. And I think that is a very good argument to say it has to proceed. It cannot wait 2 years for the virus to disappear when nobody knows when it will disappear. So I mean, cases need to be resolved as well, and that's just that's just general public interest that disputes are resolved. So I think that there's a very good case for saying there's no right to a physical hearing. But then, of course, you, as always, have to look at the legal framework. You might find indications there, but usually you don't, at least at this stage.
Mhm.
There was
Okay.
an interesting case, by the way, by the Swiss Supreme Court, I think a month ago, that it was not an arbitration case, but it was a court case. And the court president had ordered a virtual hearing. And there was no, at the time she did this, there was no legal basis for it. And there was an emergency decree that was entered a little time later to say that from now on you can move court hearings online, just to make sure that that cases get moving. But at the time when the president ordered the online hearing, there was no legal basis, and the Supreme Court said you should not have done this. So we need to make sure that in arbitration we can say there is a basis, and the basis is the duty of efficiency and the tribunal's power to conduct the arbitration.
Yeah.
So I would very much agree with you, but it's a little tricky.
Yeah.
Yeah.
There's no right answer.
No,
Carlos,
there is a right answer. But we don't know whether everyone shares it.
yeah. Oh, well, that's true. That's better said. Carlos, you have a question?
Yes, thank you. My point is that it's something about terminology, but I think it is very relevant, and somehow Dr. Rosell has already implied something about this, that it is not the same virtual hearing or remote hearing. Because in a virtual hearing, avatars and artificial intelligence would be involved. And in remote hearings, the physical presence of the parties is required, although they are in different access points. And the protocols are for the different access points, of course, to the extent that you have the parties in different places, you are increasing the possibility of failure. I mean, as simple as there is an electricity shortage or something, or the internet failed or went out for 15 minutes or something, which is something constantly happening today because everybody is using the internet at the same time. And I think that this is very important to the argument of enforcement or of such an order that eventually will be tested in court, because these cases are not diminishing but increasing, and the impact of having remote hearings has a significant impact in terms of cost and other aspects that made some cases more feasible to be resolved, as opposed of having all these issues about excessive costs created by physical or simultaneously present arbitration. It's just a comment. Thank you very much.
No, thank you very much for raising these comments. I had thought whether I should discuss this, and then I did not. You are absolutely right that virtual may not be a very precise term, and it's used casually, and it has starting to be used, and everybody used it, so I used it. But remote is clearer, and you have maybe noticed that I never say hearing in person, but I say a physical hearing, because we're all in person here, right? This is a conference in person. It's just not, we're just not physically present, but we're all present, and that is required, of course, for a hearing. So you're right to highlight this. Thank you. And you have also said something that goes to the advantages of virtual hearings and maybe or remote hearings, and maybe we should think about that a little. You said costs. It's a huge advantage of remote hearings, that the savings of costs, right? And it saves time as well, because you don't you need travel time. So and I see other advantages. There's linked to travel, of course, is the environmental impact that is lesser because of the carbon footprint. And that is, I think we have to be good citizens in this respect, and we have not been, and we knew it for some time now by zooming around the world, just not paying attention much to this. There's another advantage of remote hearings that I find important and that we probably have not explored enough, is the flexibility it gives in shaping the proceedings. Because in the classical way, you would have one big hearing normally on everything, unless you have bifurcation. But I assume you have no bifurcation. You have one big hearing where you just hear all the witnesses, you hear all the experts and all the oral evidence, the oral arguments. But with remote hearings, since organizing the hearing costs very little, you could have a first issue and deal with this first issue, and then resolve it, and then deal with something else. Or you could do the damages experts at another time. I recently had one expert who was a legal expert, got appointed on a Supreme Court somewhere. And he, as a Supreme Court judge, he was not allowed to appear as an expert in an international arbitration. And he was about to take office. And so we just, when he was appointed, we just decided we do a short hearing just for him. And then we do the regular hearing afterwards. So this gives a lot of flexibility that we should make good use of. That is for the advantages. Now, if you think of the disadvantages, I already mentioned the coordination of a council team that can be handled, but must be taken into account. I hear that it is harder, but and I'd be interested in your reactions. It's harder to assess the evidence, assess the witness testimony. And I must personally say that I don't feel this, because if you have good equipment and the witness also has good equipment, you see him on the screen and you see him quite well, and you see him quite close, and sometimes closer with better light than in a big hearing room where you have not good light, he's far away or so. So I have not experienced that, but I hear people saying this. I also hear some counsel saying it is more difficult to convincingly present oral argument. And I'm not sure about that either, because why can you not watch the arbitrators? Maybe you see them even better than you would see them in a hearing room, depending on how everybody's placed. So that is something about which I'm not sure. I will also ask myself whether by the fact that there is less direct interaction, does that somehow import more objectivity into the assessment of the record, or does it not? And I have no answers to this so far, but if there are any reactions. It'd be interesting.
Yes, well, I have one first reaction, and it has to do more with maps and engineering plans, and when sometimes you have to be looking at the expert, at the evidence, at the parties, and I don't know if I could with a turn of my eye within a hearing room and a big screen and the old-fashioned way. I don't know if my mind grasped it a little more, or it was less tiring than to have to focus when you have different screens, with one screen a document, another screen all the map, another screen. For me, I find that more difficult than having everything in the same room. Now, everybody's brain works a different way, so I don't know if this is a lack of concentration on my part or a lack of training on my part in that sense. There's people, as you say, there's people who find it easier, or maybe it's people who have grown up with a IT nearer to them all the time. But for me, one of the problems of concentrating is specifically with the evidence, not so much with people, but with the evidence being presented in different screens at different times, and you have to concentrate on all that. That I find difficult. I don't know if anybody else has a comment on that.
Other reactions, I'm happy to comment on this, but I think Jose, you had another reaction.
Your hand. Jose, you're muted.
I have, yeah, thank you. I have, but maybe Gabrielle, please go first.
No, go ahead.
Yeah, all right, thank you. Well, I fully agree with Diana. In complex cases, in particular in infrastructure cases or construction, simply when you have large maps and displays, it is very difficult to get good resolution on the screen. And as you said, you have to have at least 3 different screens. But even if you have a big screen on your desk plus 2, let's say, laptops or iPads or whatever, you don't get the same definition of the document. And sometimes some maps, some Excel charts, it is pretty difficult to read and to identify the point that the counsel are making. And therefore, I think it is not as good. I mean, the remote hearing is not as good as can be a physical hearing. And the second comment I can make is that in my experience, the arbitrators tend to be less interactive. So in remote hearings, the arbitrators, it's very rare that they have, questions. The good questions are really not so well addressed. And sometimes communication between the arbitrators is not so easy because you don't always read the emails, and you cannot interrupt all the time the discussions in order to have separate discussions in the tribunals, separate rooms. So this lack of interaction among the arbitrators and interaction with the parties, I think that's is of lesser value. And I think that it is better in this sense, the physical hearing. So to close on these comments, I would say that I think we will certainly go back to normal life, normal hearings after the COVID for complex cases. Certainly we will continue going ahead. At least that's in what I think we'll continue having virtual hearings in small cases and for sure for procedural hearings. Thank you.
Yes, you're probably right that we will, once we are able again to travel and gather safely in one room, for certain hearings have a preference for this and for others not, and we'll have to decide which is which. I must say that, but I've worked a lot on this for the last months. I now have a very big screen in front of me, but really a huge screen. And then I have 5 screens, but large computer screens, not laptops, with transcript, often in 2 languages, the speaker in full screen, and documents that are being projected. And I have my laptop for other things. So, but it is true that it's tiring, but people say, oh, it's very tiring. I say, I always found hearings very tiring, because if you really concentrate, it is tiring. So I don't find it much more tiring. But I agree that, for instance, you cannot whisper something to your co-arbitrator when you're not sure of what should be done now procedurally. Is there an issue? Should I stop this guy? Or so. And you don't want to always go to the breakout rooms, because that is a whole process, and that may be more difficult. Yes, yeah. And do arbitrators ask fewer questions? I don't know. That you apparently noticed that. I would have to pay attention to this more. Yeah. But no, what can be a hassle is when you have technological issues.
Yes.
The connections break down or so. That can be very, very stressful. Yeah.
And you know, internationally, there's just no, and I use again the same word, uniformity, but there's no uniformity in the quality of services in different countries. So sometimes, yes, that would be a real inequality to have somebody breaking off while, you know, an expert is speaking, and then you have to go from one please repeat, or no, he's off, okay, let's get him back on, and then you lose time. But I don't know, in the future, I imagine, and I don't know if you would agree with this, but in the future, I imagine that we're going to have such a mixed system of sometimes physical hearings, sometimes virtual hearings, and in the same case, you may have a mixture of both, because as you say, for one type of meeting, it might be great to go virtual, whereas for a complex expert hearing witness, you would do the physical hearing. And that has opened up arbitration, that has opened up sort of new windows into all we can do and we will continue doing. I have another question. No, somebody's saying they're leaving. Carlos, thank you very much for the presentation.
Yeah.
Diana.
Yes?
Yes, I am Carlos. Please. Gabrielle, thank you for brilliant presentation. I have two questions. One question is about the virtual hearings. In your opinion, is it possible for the tribunal to apply negative inference due to the misconduct of witness experts in the hearings? Its protocols sufficient for virtual hearings, or should the arbitration rules be modified to allow a completely virtual arbitration? That's a fair question.
I mean, adverse inferences are not based on the conduct of the expert or witness. They're based on, for instance, non-appearance of a witness could give rise to, non-production of a document could give rise to a negative inference, but not just the conduct of the expert or witness. I'm not sure, does that answer your question, Carlos?
Yeah, I understand. And it protocols sufficient for virtual hearings, or should the arbitration rules be modified completely to allow a complete virtual arbitration?
there are a number of protocols now that are quite helpful. And what I do is I have kind of compiled those and put them in a procedural order. And that so far is sufficient, yes. But we could have arbitration rules that incorporate a section on how to conduct a virtual hearing, or at least a number of guidelines, because then it all depends on the actual circumstances. There's something that we have not mentioned so far, and I have skipped, and maybe I should mention it, and that may be a reason for in the future, in certain cases, go back to physical hearings, is time zones, because depending, I have an arbitration was people in Japan and in the US, and there's very few times of the day where we can hold a hearing, because with everybody, with decent times for everybody, right? Because of course you can hold a hearing 24 hours, over 24 hours, but it would be unfair if one expert has to testify at 2 o'clock in the morning and the other one can do it at 10 o'clock in the morning. So these are things that make it more difficult as well. And probably what we have to do there is shorter days and more days because of the available time. But that has been I have found this to be a struggle as well. Yeah.
The second, thank you, Gabrielle. The second question is about the first presentation. Is specifically it's about double hatting. It's a double role as a lawyer and arbitration. This impediment will be preventing good lawyers from acting as arbitrator. That should this rule be extended to commercial arbitration or only apply to investment arbitration?
I don't think it should be extended to commercial arbitration. The reason why it arises, why the issue arises, is so-called issue conflict, right? Is because you take one position on one legal issue in one case, and then you have to take another position in another case on the same legal issue. And if you are at the same time an advocate advocating one position, and at the same time a neutral, objective person having to decide whether that is the right position, I mean, some people may be clear in their minds and can make these distinctions, but the appearance is, it looks very biased. And you have the same type of problem in sports arbitration, where which is analogous in many respects to investment arbitration. In sports arbitration, what do? You largely interpret sports governing bodies' regulations. And you always have the same type of issues. When do you ban an athlete for 1 year? When you ban for life? And this type of issue. And so in sports arbitration, you have a clear prohibition. And I remember well, I introduced it when I chaired the Olympic Games Tribunal in Nagano. That was in '98, so it's a long time ago, but nobody had told me anything about issue conflict, but there was an arbitrator was in the tribunal who came to me and said, well, you know, I've been asked by these athletes to represent them in the case that we have tomorrow. And I said, but I said very naturally, but you cannot be an arbitrator and at the same time be the counsel for the athletes in front of your colleagues. And so later this was then introduced as a rule. And it's also a little bit the same thing in investment arbitration. It's not the same thing in commercial arbitration, because in commercial arbitration, you generally have contracts that are negotiated between two parties. They're one-off contracts, and you have the issues arise out of these contracts and of the applicable law. And in addition, you'd have much less publicity, so you don't know what people have decided, and it doesn't create this dilemma that occurs in investment or sports arbitration, I would say.
Thank you, Gabrielle. No more
Question? Good.
I don't seem to have anybody else wanting to ask a question. And I believe we're quite near the end.
Now we're getting to the end, yeah.
And so I thank you very much. And I thank everybody who's been with us. I think it's been, well, it's bad for me to say it because I've spoken so much, but I think it's been very, very interesting. And I thank you so much for sharing your experience with us. It's always very nourishing for everybody to hear people from other sides of the world and from the other sides of the tribunal or of the case as such. And I would like to thank Leah for having us, and especially the technical support that we always get. Although Gabrielle has her own technical, wonderful support, which I'm sure everybody's very jealous of your 5 screens and your ability to manage your hearings in that way. Carlos Soto, I now leave the floor to you.
Thank you, Diana. I changed in English for Spanish. Gabriel, muchas gracias nuevamente por tu participación y, como muy bien ha señalado Diana, por compartir tus experiencias, tus conocimientos y siempre con esa visión que tienes de futuro. Mientras escuchaba tu conferencia tenía muchas más dudas, pero ya el tiempo nos va ganando. Decir de que ha sido un honor y un privilegio escucharte esta mañana, esta tarde para algunos los que no están en las Américas, y invitarte a formar parte de Latin American International Arbitration. Es decir, contamos con tu participación en los siguientes debates y en las masterclass, y desde luego agradecer a todas las personas que se han conectado con nosotros a través de la plataforma Zoom y de las redes sociales Facebook y Live de LIA. Muchas gracias, Diana, por la conducción y desde luego el nuevo formato que tendremos de las masterclass será la que hemos presentado el día de hoy. Nuevamente, gracias a todos, un gran abrazo, sigan cuidándose y les cedo ahora el uso de la palabra a Mauricio Michel para que nos dé las noticias finales.
Muchas gracias, doctor. Nuevamente, un agradecimiento especial a la doctora Kaufmann-Kohler. Muchas gracias por su exposición y por participar en esta 6ª Masterclass de LIA. Es un honor para el Latin American International Arbitration LIA que haya participado como keynote speaker en esta Masterclass. Un agradecimiento especial a la doctora Diana Drullers, quien moderó la presente Masterclass. La doctora Diana Drullers es vicepresidenta de Latin American International Arbitration LIA, y es árbitro internacional y consultora en materia de arbitraje. Es miembro de la Corte Internacional de Arbitraje, ICCA, y asesora a Dispute Resolution Data en los proyectos de investigación. También es vicepresidenta de la Asociación Venezolana de Arbitraje y del capítulo venezolano del Club Español de Arbitraje. Directora del Centro de Arbitraje de la Cámara de Comercio de Caracas, desde que lo fundó en 1998 hasta enero de 2015. Manejó más de 600 casos y presidió la International Federation of Commercial Arbitration Institute desde el 2009 hasta el 2017. Ha sido miembro de las juntas directivas y colaboradora de diversas instituciones que promueven el arbitraje. Es profesora universitaria y ha publicado diversas publicaciones sobre arbitraje y mediación. Figura en Who's Who Legal como líder en el arbitraje en Latinoamérica. Nuevamente, muchas gracias a la doctora Gabrielle Kaufmann-Kohler y a la doctora Drullers por acompañarnos en esta masterclass de LIA. Sin más, los invito a participar de algunos próximos eventos que se están dando en la región, que son los organizados por el Instituto Peruano de Arbitraje, el conversatorio con los centros de arbitraje este 28 de enero del 2021 a las 6 de la tarde hasta las 8:30, hora Lima. Otro evento al que los invito a participar es el organizado por el Instituto Peruano de Arbitraje, que es la primera conferencia internacional de arbitraje y minería IPA. Se organiza este 4 y 5 de febrero del 2021 a las 9 horas, Lima. El segundo encuentro internacional de centros de arbitraje e instituciones arbitrales IPA se realizará ese 17, 18 y 19 de febrero, también a las 9 a.m. Y una invitación especial al Seminario de Derecho Civil Manuel L. Puente Lavalle, organizado por el estudio Carlos Soto y Asociados, Perú, España, este 8 de febrero del 2021 a las 6 de la tarde, hora Lima. Están todos cordialmente invitados, todos son eventos gratuitos previa inscripción. Muchas gracias a todos por participar en esta Masterclass LIA. Nos vemos hasta una próxima actividad.
Muchas gracias a todos.
Muchas gracias, Gabriel.
Muchas gracias, hasta luego.
Hasta luego.